Welcome, I'm David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. During the course of a lawsuit, there are depositions that are often taken by witnesses or as to witnesses or parties. And one of the questions we get often is, what's the other side going to ask me? So let's assume that the person that I represent was involved in an auto accident, and the defense attorney wants to ask questions about that accident. In general, here are some of the things that are going to be asked. They're going to ask about background, some history. For example, where you live, what kind of education you have, maybe experiences that you've had with your personal health and well-being to determine where your status is going into the accident. Thereafter, they're going to ask questions about the accident. What you saw, what you heard, what you did in response to the situation, how your body moved in a vehicle, things of that nature. These are things that the defense wants to know so that they can evaluate your truthfulness and your experience in this accident. They also are trying to find out whether you contributed at all to the cause of the accident. Thereafter, they're going to ask questions about your injury that you claim occurred as a result of the accident. They'll ask things about where were you hurt, what did you feel, what evidence of your injury you had, things of that nature. They'll ask you about your medical appointments and the medical expenses and your experiences with the doctors or with chiropractors that may have treated you as a result of the accident. They're going to ask many other questions potentially about you and about your accident, about your experience, what you're feeling, things of that nature, and things such as did you miss time from work or your loss of earnings claims, or if any other claims about certain losses that you may have had. Ultimately, the defense attorney can ask you a very liberal number of questions in a very broad scope about the things that may pertain to your accident or your claim. Before going into a deposition, you want to make sure that you've met with your attorney, spoken with him or her, and made sure you understand the nature of the questions that are going to be asked, the nature of the responses you may have given in written discovery, so you make sure that your testimony is consistent throughout the experience, and what that attorney expects out of that deposition for you. At that point, your attorney will be with you at the deposition and will be able to help protect you to some limited degree. But you have to remember that during a deposition, the attorney cannot answer the questions for you. You're pretty much on your own in that regard. Here's the best advice that I can give to anybody who's doing a deposition. Tell the truth. If you tell the truth, then you're in a far better situation than if you try to cover the truth with lies. And I know that most people will always tell the truth. They're sworn to do so at a deposition. So if you're ready to take your deposition, make sure you've spoken to your lawyer and you can respond to the questions as appropriately and as accurately as possible.